powers of disciplinary and control that the Constitution donated to the NJC. What does it mean? Is it when the NJC exercises powers of discipline and control over judicial officers?
Right.
What does it
now,
mean?
I will speak to the two concepts.
And when you talk of the judicial functions of a judicial officer,
yes,
what does it mean?
Well, the judicial officer performs the function under Section 6 of the Constitution. It's clear about the powers of the judiciary. Then powers over disciplinary steps against a judicial officer is determining whether or not the judicial officer's conduct is consistent with his code of office. And the code of office is express and clear. So when they sit, what they determine is that misconduct complained about, whether ranking it pari passu, what is expected of him as he took the oath of office, it is consistent. Now, it is also possible that a petition can be written for which crime will be inferred, that he collected bribe or he even shot somebody. It's possible. And this crime contained in the petition may also form part of the misconduct. But the judges who sit as members of the disciplinary committee, remember, they are sitting and live judges. They have jurisdiction when they sit in their respective courts to try criminal matter. But they are not oblivious of the fact that when they sit as a council, they do not have criminal jurisdiction. Now, coming to
they are
the
not
issue,
operating as judges.
they are not
They are just administrative body.
No, they operate as judge because they take evidence. Yes, they take evidence.
Yeah.
But they
For
have
administrative
limitation.
purposes.
For administrative purposes. They have limitation. So that is why the evidence of acquittal of a criminal proceedings cannot be a ground for acquittal in criminal trial. And if, like in the case of Justice Ademola, he was discharged and acquitted, he can still be discharged and acquitted, and NJC will still find him guilty. So each, whether in the court or the National Judicial Council, the evidence of acquittal or conviction cannot be a ground to be used. Unlike in a malicious prosecution, where the minute you get acquitted by the court, you can use that to then sue for compensation. So if that one is clear, the issue of control comes. And this is where, in my opinion, I have always advocated for friendliness and collaborations in all the agencies and government organs. Now, this is where communication between the law of enforcement agencies and the NJC is pivotal. The reason is because that word control you see there,
Yes.
it means the National Judicial Council can decide to tell a judge, please do not sit like they did in this case until the case is concluded. Now, why it is necessary, not law, but why it is necessary for law enforcement agencies to notify NJC of a criminal allegation against a judge as they proceed. I won't say before they proceed, I will say as they proceed. So that the NJC, in the exercise of their powers in the Constitution for control over the judge, will order the judge not to sit until the case is concluded. Because if you do not notify NJC, it means they are not in the position to know the allegation against him. That means he can be in the dock today and be in the bench tomorrow. So that is why the communication is necessary.
Okay.
But to say that it is a condition precedent, this is a new law. So except if the Supreme Court holds the opinion of the Court of Appeal, then it has created a new gamut of law in our corpus juris, because as it stands now, there is no specific law that says the condition precedent for criminal prosecution of a serving judge. And I'll give you instances of countries. If you go to America, different states have their own different rules. In California, they have Commission of Judicial Performance. And the way they operate in California is, if a petition is written against a judge, even if there is a crime, there is that understanding that that will be dealt with by that committee before the federal or the state can prosecute that judge. If you go to Wisconsin, they have their own modus. They have, in fact, they call it Board of Judicial Discipline or something like that. In Wisconsin, a case involving a judge came up. He was prosecuted first before the board had to sit. If you go to England, they have also their own board that discipline the judges. Somewhere in Liverpool also, a judge connived with solicitors and they committed a crime. The law enforcement agencies studied them. By the time they sprung into action, at that point and at that time, there was no determination by the board or by the commission or by the office that was supposed to discipline the judges. So depending on the case, a judge also, I can't remember which of the states in England, allow her Rottweiler to bite somebody, and she was straightforward prosecuted before that, before she can be referred again to be disciplined. So there are instances where the board or the commission or the committee or the council sits over the matter. I will give it this way. If a petition had been written and the council had already started sitting in respect of a matter involving a judge, as a spirit, in the spirit of esprit de corps, it will be necessary at the point for the law enforcement agencies to wait until this matter is determined, and then they will proceed. Where there is no commencement and ongoing proceedings in respect of a judge, and in most cases the prosecution would have noticed that even before petition can come to the judges. I do not think that the law, because look at the implication. If EFCC conducts an investigation, come up with heavy evidence against a judge, writes a petition to NJC stating some of the evidence, and they have to wait until agency determine the matter. And while the agency is determining, remember they are not sitting till they determine it in one day.
Exactly.
There are adjournments and things like that. If the state will have to wait until that is concluded before they will take a step, the chances are that the evidence may be destroyed, investigation may be interfered, and I don't know, in that judgment, it was reported on social media that they used the word cannot be investigated or prosecuted. Now, if the way it is couched, that is the way it is in the judgment, then I would say that it is unfortunate. The reason is because even when you write a petition as a law enforcement agency as a result of your investigation, that means if you cannot investigate before you write a petition, then that means what you are bringing is frivolous. There has to be an investigation, and then when you have a concrete allegation against the person before you can report. So my understanding of the law is that there is no criminal jurisdiction with the National Judicial Council, and that National Judicial Council cannot, in my opinion, as a condition precedent, determine criminal law before the law enforcement agencies will
Let me read this tweet, and it's going to take the form of the next question. And the tweet is coming from Samuel C. Chukwu. It says, it appears that there is a misconception here, sirs. Once a judge is put on the stand, whether he is guilty or not, he has lost public respect. What happens if he is innocent? The arguments and examples by my learned colleagues already assume the guilt of these judges.
Well, Justice Ademola went through trial, and he returned to his court and continued with proceedings. If you get acquittal, it means nothing was against you.
Strengthening